points the other way, because what is significant is the difference in language that the Constitution uses when it deals with the calling of national conferences on the one hand and provincial conferences on the other. And that comparison, the comparison that our learned friends make, that comparison tells us that the Constitution intended one regime to govern national conferences and a different regime to govern provincial conferences. Let me just take you to the two provisions to which they point. The first is Rule 10.5, which says, that's on page 65, it says, the National Conference shall be convened at least once every 5 years. So that's the equivalent of the first half of the rule that we're concerned with. And it's significant that it doesn't have our second half. The other rule they point to is Rule 29.1, which is at page 87. And it says, a special conference of the ANC may be convened by the NEC at any time or at the request of a majority of the provinces for the stated purpose of the stated purpose or purposes. And it is interesting that if you read those two rules together, that it provides for the same two possibilities as our rule does, but then adds a third. It provides for a conference once every 5 years. That's the equivalent of our first part. It provides for a conference to be called at the request of a majority of the provinces. That's their equivalent of our second part. But then they have a third part, the one that says may be convened by the NEC at any time. So what the drafter did when it regulated national conferences is specifically to confer a power on the NEC to call a national conference at any time. So what does one make of context? What one does make of it is to look at the rules that govern the calling of provincial conferences, and you see they provide only for two possibilities. Then you look at the rules that provide for the calling of national conferences, and you see that they have exactly those two comparables, those two possibilities, but they add a third, or at any other time. The clear inference is that as far as national is concerned, they may be called by the NEC at any time. As far as provincial is concerned, they may only be called once every 4 years or at the request of the branches. So that is context. Then lastly, purpose. What is the purpose of limiting the calling of provincial conferences only on those two possibilities, once every 4 years or at the request of the branches? Well, once every 4 years is obvious. That's because the term of office of the PEC is 4 years, and therefore you have to have a conference once every 4 years. And what the second part does is to say, the decision maker as to whether we have more conferences than the minimum should be the branches. It's a bottom-up democracy and not a top-down democracy. Whether a good or a bad idea, that is the obvious purpose of legislating that more conferences than the minimum may only be held if there's a request from the bottom up. So we submit that on no basis is there an open-ended mandate to call provincial conferences other than under those two possibilities, once every 4 years or at the request of the branches. Now we can leave out the at the request of the branches because that didn't happen in this case. So it leaves us with the possibility of once every 4 years. Now our learned friends devote half of their heads of argument to a debate as to what that means. And let me make this submission. I know that there's been a debate before, but I submit with respect that the basic interpretation of once every 4 years is absolutely clear. If you have it in 1 year, then you may not have a conference again earlier than 4 years after the initial conference. my learned friends speak of the court's interpretation as if it yields an anomaly, because it says it interprets the rule to mean the conference takes place in every 5th year after the initial conference. Well, that is because 1 plus 4 is 5. If you have a conference in year 1 and you have to have a conference 4 years later, then the next conference will be in year 5. There's nothing odd about an outcome that says if a conference has to be held once every 4 years, then if you have a conference in year 1, the next conference has to be in year 5. But let me say this. I accept that there is room for debate as to precisely how that 4 years should be measured. Because one can measure it with varying degrees of specificity. The measure that the court adopted, which we submit with the greatest of respect, seems a sensible and a workable interpretation, is to say you measure it by year. In other words, if you have a conference in year 1, then the next conference must be in year 5, 9, 13, and so on. And therefore, if you had a conference in 2012, as in this case, the next conference has to take place in 2016. No interpretation gets you to November 2015. Now, that we submit is a perfectly sensible interpretation. Are there other ways of measuring the 4 years? Yes, there are. You may fine-tune your caliper by measuring the 4 years not by year, but by month. And then you would say if the conference took place in May 2012, then the next conference must be in May 2016. You can tune your measurement even finer than that and do it by day and not by month. If the previous conference was on the 11th of May 2012, the next conference must be on the 11th of May 2016. But that fine-tuning of the measurement is a nice debate, but utterly irrelevant to this case. Because on no possible basis, if you have a conference, we know that the previous conference was in May 2012, on no possible basis is 4 years after May 2012 get you to November 2015. That is 3 years after the 2012 conference, not 4 years. So that the debate is truly a red herring, because regardless of the outcome of the debate, on no possible interpretation was it competent to have a conference in November 2015. So we submit with the greatest of respect that where there is room for debate, i.e. about the precise measurement of the 4 years, that debate is irrelevant. On the fundamental interpretation that there are only two possibilities, once every 4 years or at the request of the branches, the respondents do not bring themselves within either of those two possibilities, and there's no viable argument that brings them within either one of those possibilities. And we submit with respect that there is absolutely no prospect of persuading a court of appeal that there is a third possibility, incompatible with the language, incompatible with the context, incompatible with the purpose.
Mr. Trengove, is anything to be made of the words in Rule 17.2.1 of at least once? You know, if it said shall be held every 4 years, no. But for better or for worse,
it does say
it says at least once every 4 years.
It does say at least once.
We concluded that it means once every 4 years.
Yeah. Well, it says once every 4 years, and then the second part tells you that you can have more conferences, but only if there's a condition for having more conferences. The condition is a request from the provinces. And the language...
Sorry, from the branches.
From the branches. The language can't be clearer. Must be held at least once every 4 years, and more often, not more, and more often if you wish, more often if requested by the branches. So there's a condition for holding more conferences than the minimum.
No, there's not even a punctuation separation or anything.
No, no. So we submit with respect that not only is the interpretation obvious, but there is no reason to delay the finality of this case. And let me also say with the greatest of respect that this is a full bench judgment, judgment that has the status that an appeal judgment often would have. So that there is also less reason to be insecure about the outcome because it is a considered judgment by a full bench. Could I turn to the Paja time bar point? We submit with respect that what the argument overlooks is that there are really 4 potential causes of action. And Paja only governs one of them. And you can't superimpose the requirements of Paja on the other causes of action. And let me just explain why I say so. The 4 possible causes of action, and that is really common cause, both sides, heads of argument and the judgment, and the Ramakatsa judgment makes this clear. The first cause of action is in contract. And that is because the constitution of a voluntary association is a contract between all its members, and if the constitution is violated, a member has standing to enforce it in contract. It is a good, solid, common law contractual cause of action. It's got nothing to do with public law or administrative law. It is a private law cause of action. And then there are 3 possible public law causes of action. In Ramakatsa, it recognizes a cause of action for a violation of Section 19 of the Constitution. That was the other cause of action upheld in Ramakatsa. That is a public law cause of action, governed by the rules of public law, and it ends up, if it succeeds, in Section 172 of the Constitution, which confers on the court a wide remedial discretion, equitable discretion. That's the second cause of action. Then there's a third cause of action for violation of Section 33 of the Constitution, the right to fair administrative action, which has been fleshed out in Paja. So the third cause of action would be an administrative justice cause of action, subject to Paja. The last cause of action, the fourth cause of action, would be a rule of law cause of action. And that's in fact the rules of public law that would govern the exercise of public power which does not constitute administrative action. And it is subject to the rule of law under Section 1C of the Constitution. It also ends up in Section 172 of the Constitution. Now, if I may call these last 2 causes of action, the administrative justice cause of action and the rule of law cause of action, if I may call them just for shorthand the administrative law causes of action, because they are very similar. One set of rules governs administrative action, another set of rules governs the exercise of power which does not constitute administrative action. But what the 2 of them have in common is that they are concerned with the judicial review of the exercise of public power. And they have all the rules of administrative law govern that exercise of public power. There are public law rules that govern the exercise of public power. One other feature they have in common is that those public law rules, the administrative law rules, are subject to the Odekral rule. That's the rule that says that an administrative decision, or the decision taken in the exercise of public power, stands until set aside. The other feature that both of them have in common is that they end up in section 172 of the Constitution. They give the court a wide remedial discretion. Then one other feature they have in common, and that's the important one, is that they are both subject to a time bar. Because as the court said in Odekral, that remedial discretion of the court is exercised to strike a balance between legality on the one hand and certainty on the other in the public interest. But I must emphasize that these features, the Odekral rule, the remedial discretion, the time bar, whether under Paja or at common law, they are features of these two public law causes of action. And they apply only to the public law causes of action. They are not applicable to contractual causes of action. And in this case, we submit with respect that although the applicants may well have made out other causes of action as well, they succeeded in establishing a contractual cause of action. The contract was the contract that constituted the constitution of the ANC. The was breached in that clause, or rule 17.2.1 was breached. That is a contractual cause of action. And whether or not it is also capable of being characterized as the unlawful exercise of public power is neither here nor there. It is in the first place a contractual cause of action. And may I, on that score, just refer to 3 paragraphs in Ramakatsa's case. So we have some cases that we can hand up. If I may refer to Ramakatsa's case, firstly paragraph 16. Where the Constitutional Court said of a similar case, I do not think that the Constitution could have contemplated political parties could act unlawfully. On a broad purposive construction, I would hold that the right to participate in the activities of a political party confers on every political party the duty to act lawfully in accordance with its own constitution. This means that our constitution gives every member of every political party the right to exact compliance with the constitution of a political party by the leadership of that party. And then paragraph 79, where the majority judgment says the following, if I may leave out the first sentence and pick it up in line 3. At common law, a voluntary association like the ANC is taken to have been created by agreement, as it is not a body established by statute. The ANC's constitution, together with the audit guidelines and any other rules collectively, constitute the terms of the agreement entered into by its members. Thus, the relationship between the party and its members is contractual. It is taken to be a unique contract. And then in paragraph 80, as in the case of an ordinary contract, if the constitution and the rules of a political party like the ANC are breached to the prejudice of its members, they are entitled to approach a court of law for relief. And they cited Saunders, which said the following: there is no doubt that the rules and regulations of a body like the Stock Exchange, just like the rules and regulations of an ordinary club or the articles of association of a company, constitute a contract between its members, and that is the reason why any particular member, if the contract is broken to his disadvantage, has the right to come to court for the appropriate remedy. So whatever other rights the applicants might have had, they had a contractual claim. This court upheld the contractual claim. I don't need to take the court to the paragraphs in which it did so, but if I may just give you the numbers of the paragraphs. They are paragraphs 37, 61, and 110. this court made it clear that the applicants had established a contractual cause of action. And we submit with respect that that conclusion was inevitable. And given that that is so, the contractual cause of action is subject to the common law. It's not subject to public law. It's not subject to paja. It's not subject to the rule of law. It is an ordinary, conventional, contractual cause of action, and it is not subject to any time bar. Private law has other rules, and you know the rules of election and waiver and estoppel and so on. Those things are the regulating mechanisms that may cap one's freedom to bring a cause of action. But none of them are in play here. So that we would submit with respect that the suggestion that the claim was subject to a paja time bar overlooks the fact that the claim is in the first place a contractual claim which is not subject to any time bar at all. If we're wrong, then there is the debate as to whether it is paja or the common law that applies, in other words, whether it's administrative action or the exercise of public power. We submit that by no stretch of the imagination can the calling of a conference by a political party constitute administrative action. It does not affect the rights of outsiders. It does not have any direct external legal effect on others. So we submit with respect that even if we're wrong in our primary submission, that this court was correct in holding that it was not paja but the common law time bar that operates, and that the application was brought within a reasonable time, given that the party delayed its promised response to the complaints when they were first made. So for these reasons we submit, my lady, my lords, that there is really no prospect at all that another court will come to a different conclusion. Our learned friends say that there is another public importance consideration, even if they don't show prospects of success. We submit with respect that if there is a public importance consideration at play, then it is one that dictates that this matter should be brought to finality rapidly rather than slowly. The public interest is better served by a prompt conclusion of the legal process rather than one that is drawn out. All of these matters are going to become irrelevant over time once the following conference is held. If there is a public importance in this matter, then it is that finality be reached as quickly as possible. Nothing can be said to the contrary. So we submit with respect that there is indeed a further consideration beyond the prospects of success why leave to appeal should be refused. We ask for the costs of the application, including the cost of chief counsel. Thank you, my lady.